Welcome to Cornell Cooperative Extension of Tompkins County and our monthly Consumer Issues Program. I'm Carol Fisher, Consumer Educator here at Cornell Cooperative Extension. Today our topic is landowners' rights regarding oil and gas leases. Whether to enter into a gas lease or oil lease to one's property is a complex decision, and at the very least the landowner should really know what the legal terms mean and what they're getting into. So what are the questions that need to be asked? What are the ramifications for the property owner who decides to lease their rights? What happens if you decide not to lease, but most of your neighbors do? What happens if you change your mind later? Today we have with us Assistant Attorney General Mike Danaher, who's here to explore the legal side of gas and oil leases and to help us make more informed decisions and to answer our questions. Mike, welcome.
Thank you, Carol. Good morning, everyone. Welcome to Cornell Cooperative Extension for our Consumer Issue session. We're talking about a topic that's, I'd call it kind of in limbo right now because everything is up in the air regarding the oil and gas leases. And the most important thing, as we always advocate here at our Consumer Issue sessions, we have to be good consumers when we're considering this or any other type of transaction. I think I'd like to start out today by giving you kind of a current events report, kind of what's been going on out there so that we can all understand. And then we'll talk about leasing in particular. For those of you that don't know the current lay of the land with regard to leasing and to oil and gas issues in New York State, there's been a lot of litigation going on. I understand there's a new case starting today on an issue, so there's a whole mess of things that we need to talk about. And the best thing to do is to talk about where we are, what kind of has happened. 5 years ago, approximately, the then governor at the time had directed that a certain type of drilling would be on hold, or that the Department of Environmental Conservation, which issues permits for drilling, would not be issuing new permits until an extensive investigation had taken place regarding the different impacts that a particular type of drilling was having throughout New York State. Just to give you an idea what it is, some people think that, and it does lots of times, drilling would just, you stick a pipe in the ground and just suck whatever's there out of this pool, whether it's a pool of oil or a pool of natural gas or water, drilling for water, except the water table's a little bit higher than what they're talking about here. But so you just think of you sticking a straw in the ground in like a glass and sucking whatever's in that glass out. But it's not so easy. That's the way that everybody would think about it. But they're developed over the last 10, 15, 20 years. It's been going on longer than that, but in the last 10 to 20 years, a new technology has occurred whereby the gas drillers aren't going necessarily at this one glass to put their straw into. What it is there's cracks way deep down in the ground. I'm making this very simple. Way deep down in the ground, there's these cracks. And for lack of a better term, little pockets of gas. They're gas hooked within the shale formations. And so they figured that a way to get at that, you can't just stick a straw in the ground. I hate to use these analogies, but it probably sounds the best, is if you've ever had one of those all those drinks that you get at the convenience store that has the ice chips in it, the really crushed up ice, and you put your straw into it and you suck out the ice and the drink that's there, and then it stops. But right next to it, there's more ice, and you can stick your straw back in and pull more out. Well, with all these little cracks in the ground, they would go drill down, and they would get the one part around the shale and any gas that forms there, but there might be some right next door. So how did they do that? They did this thing called hydraulic fracturing, which is they actually drill straight down and then they go horizontally to where they can start picking up the gas from the shale formations as they go along. And that had led to a lot more ability to develop these and extract the gas. Back in the olden days, when everybody thought it was just a glass and you put a straw into it, there were certain rules that were adopted by the Department of Environmental Conservation. There was an environmental impact statement done and set up parameters of how this pool of minerals or whatever could be extracted. And everybody thought, well, it's drilling. You drill straight down. Now all they're doing is drilling sideways. So we can just use the environmental impact statement that was in existence for this original technology and just convert it over, and we'll get permits based on that. Well, as it turns out, it was determined that the impacts for horizontal hydraulic fracturing, and again, to kind of make it a little more complicated, what ends up happening is as the drill bit is going through, they blast under very high pressure water and chemicals and sand to open these cracks up to allow the gas to flow. And so the determination was that that's different than just sticking a straw on the ground and pulling gas out. So the environmental impacts may be different. So we've got to undertake a study to see, are there other environmental impacts going on here? What other restrictions should be in place before permits are issued? So that kind of fast forwards it to approximately 5 years ago when the governor said, hey, we want to update the generic environmental impact statement that was in existence for our glass to try and see what we have to supplement that for this new type of technology. And until that all gets taken place, we're going to put things on hold, and we'll wait to see how that all plays out, whether we'll do it or not do it, what restrictions are going to be imposed to do that. So that put us in 5 years ago, and the study has been going on for the last 5 years, and so no decision has been made yet as to whether or not permitting for this hydraulic fracturing will take place and be allowed, and if in fact it is, what conditions and restrictions and other things may be imposed. As it currently stands, the governor has asked the Department of Health to do a health review, and as I understand it, the health review is still ongoing, and when that gets completed, depending on what it says, then determinations can be made down the road whether or not this type of technology will occur. Now, that said, there still is in place the regulations related to putting the straw into the glass, and drilling can still take place, permits can still be issued for that kind of technology, except that by accounts out there, the mother load is supposed to be the gas that's trapped in the shale formations, which the gas companies would like to get at through horizontal hydraulic fracturing. So as a practical matter, since that's the mother load and that would be the one that would be able to generate the revenues to be able to carry on the technology and do the drilling essentially has been relatively halted until that technology can be ironed out. So that's the current lay of the land. There has been, well, let's step back. Up until the time that the governor directed that the supplemental generic environmental impact statement be done, there was, first of all, a mixture of all these events that came together that made it very ripe for gas prospecting and drilling, and that is the price of natural gas was very high and therefore more lucrative. This new technology came into play where it was be able to be used on a more broader scale, became more refined, and so the gas company said, hey, we got to go after this shale. So what ended up happening is that in order to gain access to this, although very deep in the ground, the gas companies had to acquire the rights to get at it. And in order to acquire the rights to get at it, they had to go out and lease the rights with the landowners to gain access through drilling, allow drilling to take place. And because the prices were so high, everybody was jumping in to try and get their feet in here. And as a result, people were going out to landowners, knocking on their doors, asking them to sign leases to allow for the extraction of gas. And it literally was a matter of weeks that the prices that people were being paid for their land to lease exploded. It was, somebody might receive and I'll get into the particulars of it later about how the financing goes, but people receiving, just for the right to drill in their property, they may have 2 weeks before been offered $100 an acre. And then within about 3 weeks to a month to 2 months, it was up to $1,500 and then to $2,500 per acre for the same thing. So we had a whole host of issues related to that, because I was receiving telephone calls from people that signed early on and had only gotten $100 or $500 an acre, and they found out 3 weeks later that their neighbor was getting $1,500 an acre, and they thought that they got ripped off and were coming to complain to us. So that was kind of the lay of the land back at that point in time. Well, since the supplemental generic environmental impact statement has been under review, leasing has come to a virtual halt. Nobody has any real idea of how this thing's going to play out. So the gas companies are not going to be paying money to lease people's land unless they know they can get at it. And so it's all been kind of on hold, which is a perfect opportunity for us to now talk about it, for the fact that if it were to happen in New York, now's the time to know, so that going into this whole situation, when and if things were to come back, or for those of you that may have a glass that they need to put a straw in that would still be available to you, you will know what the kind of things are that you should look for and make your decisions as to whether or not you want to do this or not do this. And again, you need to be a good consumer when that comes up. And we'll talk about that in a couple minutes. So, as far as current events go, some of the litigation that has occurred. The first item addressed is, I'll refer to as the Dryden Middlefield matter. And there are some towns throughout the southern tier, principally because that's where the shale gas is at least identified as being prevalent. A number of towns have made some decisions as to whether or not they want it or whether they don't want it drilling in their particular town. And the towns of Dryden and Middlefield adopted local zoning ordinances that would, in essence, prevent the hydraulic gas drilling to take place because of the restrictions that would be imposed. And so they effectively have said, well, we've enacted a law that prevents gas drilling from from coming in here. It gets a little more complicated than that, but we'll just leave that as the general rule. And of course, some landowners who wanted the ability to draw income from using their mineral rights, their gas and possibly oil, it's mostly gas here, said, well, you can't take this away from me. So they sued, and gas companies as well who want to drill, sued the towns saying under the environmental conservation law in New York that state law preempts the local zoning ordinances and you can't prohibit that. That was sued on. The trial court found in favor of the towns and said no, local zoning laws, home rule takes precedence and they can do that sort of thing. It was appealed to our first appellate level, which is called the appellate division. The appellate division did what was referred to as affirmed, meaning they supported the original trial court decision, and then that decision has now been appealed to the New York State Court of Appeals, which is the highest court in New York State. As I understand it, the briefs are all filed. It's anticipated that the case will be argued sometime probably in June, May, June timeframe, probably June, with maybe a decision sometime before the court adjourns in the summer. So that's kind of the status of that. So currently existing, the law is that the local municipalities, based on a case I'll talk about in a few minutes, as long as it's done properly, then the towns can effectively zone what can take place within their boundaries. So it's up to the Court of Appeals to decide that issue. So that's one litigation issue. Another litigation issue was that, kind of along the same lines, is I'll refer to it as the town of Sydney matter, where the town of Sydney also stepped in to impose a moratorium. In some instances, there would be an outright ban of this technology, hydraulic fracturing. And in some instances, municipalities have enacted or purportedly enacted these moratoriums, which might not be for forever, but it might be for a definitive period of time, so that the municipality can get caught up to speed on what ramifications might occur within the town as a result of this technology. Maybe they want to take up issues of, how do we handle the heavy truck traffic? How do we handle our roads? Do we limit where the trucks can go? Do we have them pay money in case the roads get destroyed from the heavy trucks? Or for any other host of reasons, or maybe even a moratorium to decide, well, do we want to enact local zoning laws or whatever. So the town of Sydney adopted a moratorium ostensibly under their zoning laws. Well, in order to revise or impact your zoning laws, one of the things that had to be done was that they had to submit the proposed activity to the planning commission of the county. And what ends up happening with that when you do that is that the county can say, yeah, hey, that's a good thing, go ahead. Or the county can say, no, not a bad idea, and kind of reject it. If the county rejects it, the municipality, and this is true of most planning issues that have to go up to the county, is that if it comes back to the town in that case where the county gives a negative recommendation, the town council that would be undertaking this zoning change or effective zoning can still pass it, but they have to pass it with a supermajority of their board rather than a majority. And what happened in the town of Sydney matter is they got a, without going into the details of how the county planning board issued the decision or anything, but county planning board said we disapprove, and the town board went ahead still and voted by a majority to enact this moratorium. And on top of that, before they undertook their action, they were presented with a protest petition from members of the town, which provides that if 20% or greater, I don't think it's greater than 20%, I think it's 20% or greater. It could be, I could be wrong on that, but it's more than 20%. In this case, it was more than 20% of the owners of the land acreage, so 20% of the acreage, protest the action undertaken by the town board. That also triggers a supermajority. The town went ahead and voted and said, and ended up voting it by a majority, not a supermajority, and they went ahead and said, well, it's all okay, our moratorium is in place. Well, they were sued by those people who were part of the greater than 20% of the land acreage, and went to court, and the court decided that, yes, you needed to have a supermajority in order to enact that moratorium, therefore they threw it out. The current status of that is the court threw it out, and I think the town is considering whether to appeal or not, and I'm not sure what. There's a certain period of time within which to appeal that decision, or it stands for good, and at this current stage of that is I think their appeal time maybe by the time you watch this on TV, the actions will have been taken, their time would have expired, but as of right now, it's getting near the end from what I understand. The last case in particular I want to talk about is the City of Binghamton case, which the City of Binghamton enacted a moratorium, not using their zoning powers, but claiming that they're using their police powers of protecting the people of the City of Binghamton, that they could enact this particular moratorium. That case was sued by some owners of property within the City of Binghamton, and the court found in favor of the residents that it was not a properly adopted moratorium, and so the city itself could not issue the moratorium, and threw it out. And the city appealed that decision to the appellate division, it's the immediate middle level appellate court. And just recently, the new mayor of the City of Binghamton has directed that appeal be withdrawn. So
For clarification, Mike, that was a procedural issue, not ruling on the police power as being an acceptable approach.
It was based upon the a determination that it was not properly enacted. It wasn't decided on the substance of it one way or the other. It was not properly done. And similar with the town of Sydney. The town of Sydney matter was a procedural matter because they didn't have the proper approvals done. So those are the status of those things. So a lot of these cases do come down also to the procedures. See, when I originally talked about the Dryden Middlefield case, you recall that I said that as long as it's properly adopted, if it's properly adopted, the current state of the law is such that towns can use their zoning powers. So where do we stand presently? We stand presently in a state of limbo, so nobody really knows what's going on. And in the meantime, there are leases out there that people have entered into that nobody can really do anything. I mean, they could stick a straw in the glass, but it's not really economically feasible to do that in most instances, so everybody's just kind of on hold. And what it's led to is the gas companies had paid a significant amount of money to lease lands from people, and they were for a finite duration. At least in the initial instance, was a finite duration, which was for a period of the early leases were 10 years. I mean, real old leases back in the old drilling days in the 18 and 1900s early, they could be 20 years. But more recently, it got to be where it was 10 years, and then it whittled its way down to 5 years. So there's a lot of the 5-year leases out there. Well, this whole process has been on hold for 5 years. So what is happening now with all these leases out there? The way that the leases were generally written is that it would be for the company would be paying for the rights, just the rights to drill, explore, whatever, to see even if there is gas down there, and if there's not gas down there, they move on. But they just to have the right to do that. They had a period of 5 years, and the way that it was really designed was that, I'm just using 5 years. Could have been 10 years, could be 3 years, but I'll just use 5 as a good example. Which gives them the 5-year window to do what the contract allows them to do. And this is a contract. This is just a contract between the landowners and the exploration companies. Just a agreement. So for 5 years, you have the right to do what it says you have here, which is to explore and extract and whatever. If they don't do anything within the 5 years, presumably it just expires and then moves on. And that's what kind of happened before this whole wave of horizontal hydraulic fracturing. Old-time farmers would sign on a lease for $5 an acre or something, not expecting ever to have anything drilled, and that's the way that it was. There wasn't a lot of drilling going on, and they got paid $5 an acre, and they were happy. And 5 years later or 10 years later, the gas company would come back to them, oil company would come back to them. It was oil company back then. We'd come back to them and say, hey, we want to lease again for another 5 or 10 years, and we'll give you $5 an acre. Sure, what the heck. And they have hundreds of acres, and they get the $5 an acre, and it gives them a little extra money, and everybody's happy. Well, all of a sudden, this whole horizontal hydraulic fracturing, and everybody was like, wow, they may actually drill within the 5-year period of time. And so it came to the point where we're saying, okay, well, they want to drill, but they can't. Before, it was like, yeah, we'll give you $5 an acre. If we get around to it, we don't. Now it's like, we really want to drill, but we can't because the state won't issue a permit for us to do this. You can see them sitting at the table going like this, saying, I want to get there, I want to get out, we want to do work, and we want to get there, but we can't. And so they were taking the position that under the terms of their lease agreement, that they could hold the landowner in for a term longer than their 5 years because they were ready, willing, and able to drill, to explore, do whatever, and they were an outside force, a third-party entity the state was preventing them by not issuing the drilling permit. So they use this term called force majeure. It's a French phrase that in essence says that the meaning of it is if the party is ready, willing, able, wants to perform under the terms of the contract and is provided, it's unforeseen that this outside event occurs that prevents them from performing, that the contract doesn't necessarily end. And frequently these things were kind of, the force majeure principle was used in situations where, let's say there was a shipping contract and weather out in the ocean prevented the company from getting their ship into the port, but they were ready to come in and they were out there. This principle said, no, you can't cancel the contract. They're just waiting out. They're going to eventually get in, and they perform within a reasonable period of time. So the argument then moved over to these contracts, is these force majeure extensions under the contract. Is it there or isn't it there? And that's where our office got involved at a point in time because we, although we don't get involved in the contract dispute and contract interpretation of what somebody's contract is, our position is in certain contracts, there was no provision to allow the contract to be extended under terms of force majeure. It didn't say that. That's not what the contract said. So you can't all of a sudden impose terms in a contract that do not exist. They were not there. And so we approached, initially it was Fortuna Energy, and then subsequently it was Chesapeake, to raise this objection with them, and that and I'll just bring it up to speed it along here, up to the Chesapeake. Our office entered into an agreement with Chesapeake a couple of years ago, which Chesapeake agreed that they would not use the claim of force majeure. They would not use the environmental review. I'll refer to that as the environmental review, the supplemental generic environmental impact statement that's currently going on. They would not use that as an excuse to extend leases past the date of December 31, 2013. They would not use that as a basis to carry leases forward. In essence, would mean with those leases that the sole basis for extending the lease was due to these claims of force majeure, those claims ended on December 31, 2013, and that if there was no other basis for extending any of the leases, those leases must have expired, and that they would subsequently be released. That time, I don't know, I don't know if they didn't expect it to last that long or whatever, but we thought that it was a reasonable accommodation for everybody to kind of set an outside date. Now, although we're past that date, so everything else before that really doesn't matter. But for those landowners who thought that force majeure should not apply or that their contract shouldn't be interpreted in a particular way, they were still free to pursue those defenses, so to speak. And some did. And as a matter of fact, there was a court decision that came out that said that, yes, there was no force majeure extension in the private litigation matter under the terms of particular contracts. So the lay of the land currently is that Chesapeake has agreed for those particular leases, and there are thousands of them, that they are no longer in effect and that they're in the process of releasing them. To bring you up to date on the status of releases, I've had conversations with Chesapeake's counsel, and that what they were doing, their obligation really would be to give to the landowners a release, and then the landowners would have to have the wherewithal to go down to their county clerk's office and record them and spend the money to record those. In speaking with counsel, Chesapeake has agreed that they themselves will do the recording. And as I understand it, they're going to do them in batches, which the county clerks, depending on the county clerk that you talk to, may have limitations into the batches, because what will end up happening is they'll have one document, maybe it'll be several pages, but they'll have one document that will release all these leases. And what the rule is, at least in some county clerk's offices, you can only do that for a certain number. You can't come and have 1,000 of the leases released on one document. So I think they're doing it, I think it's like batches of somewhere in the neighborhood of like 25. So they have to pay those. So they're in the process of working that out. As a practical matter, I'm also, stepping aside, I'm also in the process of attempting to get a designated address at Chesapeake for people to contact on this particular issue. Currently, my advice is that if you're in need of getting your release right away, and I'll talk about whether you need it or not right off emergency-wise, but if you need it right away, the Chesapeake entered into an agreement with us, and as a part of the agreement, without getting the particular terms of it, there was an address in the agreement that specifically says, inquiries regarding this matter can be sent to this particular address. I don't have the address right in front of me, but that's the address I would suggest that people use. If somebody needs that address, they can contact me and I can get it to them. To write to Chesapeake, but that's not the greatest result, because that address was for really a different type of issue, but it's the only one that we have to use. It's I think a dedicated P.O. box that it can go to. If we get a better address, we can get that out there. In addition to that, Chesapeake's counsel told me that they're in the process of getting a dedicated 800 number so that people can call that number directly. So that remains to be determined, but we're hoping that that will facilitate. And the reason for that is Chesapeake has agreed to release all of these and is in the process of doing so, but again, it's thousands. And some of the leases can be extended for other reasons. So some leases may not be released because of other extension provisions that the parties agreed to. So it's flushing out which ones are which, and then there's thousands of them. And so they're going to get to that. If, however, first of all, that means because they expired, Chesapeake can't show up at your house with a drilling rig when your lease expired on December 31. So you don't have to worry about that portion of it. But if you're refinancing or you're selling or some reason why you really have to get that off the record, as a practical matter, it's not of any effect anymore. But if you need to get it off the record, that's where we have you to contact the Chesapeake so that they can take care of yours in an expeditious fashion. If you just want to get it off because you don't like it being on there, it's going to take place. So you can hold off. But if you really need it for a particular reason, you can
Mike,
get it.
in terms of if you can wait, but you're interested and you want to know, if Chesapeake files these batches with the county clerk, does that end up then actually being on your own personal land record as a termination?
Yes, it terminates all the records in the county clerk's office is land records, and it follows land. If your mortgage is a lien against your land or a judgment against you, although it's a judgment against you, the real reason why it's filed in the county clerk's records is because it becomes a lien against your real property. That's how this lease created a lien on the property to begin with, because it was filed. So in order to take it off the record or to remove it from the record, they have to file a release. So it runs with the land. So when it gets filed, it gets docketed against the land. It's really not, the lease is not personal to you. I mean, it is personal to you, but the effect of recording it is really is not to show that it's personal to you. The reason for recording it is to show that it's a lien against real property. And so once that lien gets released, it's no longer a lien that potentially impairs the marketability of title.
What we have found, though, is sometimes it's not actually, if I go look at my own personal property record, it's not necessarily there. You may have to go to the clerk and say, has there been a filing by, in my case, Annsborough, of releases? And that's a separate list like one of these batches. So
Well, it's just
quite as direct.
Well, it depends on the searching that you do. The purpose is the lien against the real property. And of course, it has to be properly filed. It should really be filed. It should be filed so that the search of any owner of the real property should be able to pick up that particular lien. Otherwise, it's outside the chain. If it's outside the chain, that could impact whether or not it was a valid lien to begin with against the real property. If it isn't such that it can be identified, because that's how people tell if there's any liens against the real property is commit a search. And if you do a search and you can't find it and it's not properly, then there is exposure. I don't know, exposure to the fact that there may not be a lease to begin with, or a lien to begin with, or second of all, exposures to the county clerk if it's not properly recorded.
Stating that my lease will be resolved to my satisfaction, but then in the next sentence it says the execution and recording of the release of oil and gas lease is subject to full reservation of rights and shall not be considered an omission by Chesapeake that the lease had terminated.
That's
double time.
It's a letter that Chesapeake has sent to you that's saying that they're going to release it, but they're not going to be.
Last 8
held.
So it hasn't happened.
Yeah, I don't have an interpretation of that letter. I haven't seen that letter. I don't have an opinion about that letter. So that's kind of the current status of those particular leases. There are some leases that would still be in effect if the parties agreed that they could go on longer than what the original term was. For example, I'll just use an example. An example is, first of all leases provide that if operations were taking place on the property, so if the drilling was taking place on the property, that it would continue for so long as operations were taking place on the property. So that could be it. Another way is that in some leases, there was a provision that said that it's a term of 5 years, but then the next paragraph said, and it can be extended for a term equal to the primary term, which was the 5 years. For another 5-year term, it can be extended at the whim of the gas company, and the gas company could possibly have extended that for another 5 years. So our agreement with them only applies to extensions that were based on the claims that this environmental review prevented them from drilling. So hopefully that part of it will get taken
Can I
care
ask
of.
you a question, Mike?
Yes.
I get requests from people often, if there is an extension term and within the time frame of the lease as required, the gas company sends a check, tenders a check, and the person doesn't want the extension, they wish they'd never signed that thing. The question they often ask me is, if I don't cash the check, does that mean that they don't get the extension, or should I just cash the check because it's too bad anyway?
Well, they should talk to their own individual attorneys about whether or not they should cash the check or anything like that. But as a general rule, you can't shoot yourself in the foot. So you can't get out of that extra 5-year extension by just not saying, I don't want the money, don't give it to me. As long as the party tenders the payment, then they fulfilled their obligations under the contract. Then another issue that cropped up that resulted in some leases being terminated is that no tender was made at one point in time of any extension payments. And because no tender was made, the court found that there wasn't. So it's just a question of the parties fulfilling their obligations.
And if the person doesn't accept the check, I think the gas company letter said that check will then go to the state.
Well, what ends up happening is the gas company tenders the check, so it's really the money of the landowner, and the landowner doesn't take it or anything. The gas company's position is, hey, we tendered payment, we gave them the money. It's not our money anymore, it's to them. And in any situation where somebody has somebody else's money, there's a requirement, there's a thing in New York law called abandoned property, and the abandoned property goes to the state comptroller. So the money gets turned over and the comptroller has this money, and then whoever lays claim to that money, the legitimate rightful owner of that money, can approach the comptroller and get paid. And frequently you'll see that situation in estates or something where an heir can't be found, but they know that the heir is around and the money is available, and so they have to pay the money into the state, and then the state just sits on it forever until their heirs come and take it. In this situation, assuming that that's what the position that the gas companies are taking, they're turning the money over to the state comptroller, and then there'll be a list that'll be listed under their name. And frequently, if you go to the state fair and the state comptroller has their computer up for abandoned funds, and you put your name in the computer, that your name could show up as having funds available to you.
So could the person, the lessor, if they now realize that it's going to their lease is extended anyway, could they go to the controller's office and look for abandoned
If the money,
funds and get it
yes,
back?
if the money has been paid over to the comptroller, then the comptroller pays it all back. So that's kind of where we are currently, but just quickly, as far as those of you that might be at some point in time, just another current issue is that just recently, because of the harsh winter we've had, I mentioned before, one of the part of the perfect storm that came together that caused all this big dollars and hoopla back in the in the day was because one of the factors was the gas prices had escalated. Well, they plummeted. You know, read articles in the newspaper that power plants are converting over to natural gas from other forms because gas prices were so low that it was so much cheaper to produce energy, electricity, with gas-powered power plants because the prices were so low. And consequently, if the prices are so low, there's not that much incentive to go in and drill. So that's another factor. In addition to the environmental impact statement review that's going on, the prices have been depressed. Well, more recently this winter, with the harsh conditions that we've had, prices have spiked, at least on the per day market out there. I don't know if that's going to be a permanent thing, whether it's going to go up for some point in time, and who knows. But there might be more interest going on if prices start to go up. And if that's the case, and all of a sudden there might be a point in time where leasing were to occur again, you have to be a good consumer. And in being a good consumer, you have to understand what it is that's going on out here, and you have to make the decisions that works best for you. I'm only going to talk about just getting the lease and deciding it. There are separate issues that you need to consider, and first and foremost, you need to have an attorney who's experienced in this field to represent your interest, to protect you and what is unique to your situation. There are environmental impacts, as we've already talked about, that could impact this whole thing. You may decide that you don't want it done. You may decide that you want it done, but you want certain conditions. You may decide that you want it. You're okay if somebody takes gas from your property, but you don't want the drilling to actually take place on your property. So you have to make sure, based on your individual circumstances, that all those special things that you want in, get in. Do not rely on anybody saying to you, oh, yeah. No problem. We'll all take care of it. Make sure it's in the written document, because it's the written document that governs. If it's not in the written document, it is not going to cover you. So if the person says to you, yeah, we won't drill on your property, but there's no prohibition against it in your lease, you very well could have a rig pull up and you say, whoa, you told me no drilling on my property. The first thing that anybody's going to do is they're going to pull out the lease. They're going to look and say, where does it say that on here? So every single term that you want in there should be in there. Drilling has been around for hundreds of years, if not 100 years, if not more. Wells have been drilled, and you need to protect yourself. People were previously just happy to get their check, and now there's all these other issues. Understand that a lease is a contract, simply a contract. All terms are negotiable. I don't care if it's a pre-printed form. And that provision that you don't want in there, well, it's on the form. I mean, we can't take it out. Well, if you don't want it, you don't sign it. It doesn't take much to cross it out and put your initials next to it. There's nothing wrong with that. So every term is negotiable. And now, that's not to say that I'll use the gas companies, because they're the ones primarily on the other side, that the gas companies negotiate that. They may say, no, that's a term that we require in our leases. You say, but I don't like it. You say, well, that's not negotiable for us. They say, okay, then we don't have an agreement. But make sure that you negotiate all the terms that you believe are important to you. Certain things. This lease gets filed in the county clerk's office, as we talked about before, and becomes a lien against your real property. You need to get an attorney's advice before you go ahead and do this. Many people were signing these leases when somebody came up and knocked on your door and just said, here, will you please, you want to sign this? We'll pay you a few bucks. And no, do not sign without getting advice. There are different aspects of the lease, how much you're going to be paid. Don't be blinded by the number. I mean, even if rates were to go way up high, don't be blinded by the number. There are so many other important terms that need to be in that lease, so make sure that it's covered. The payment terms are generally the bonus payment, which is just a payment for the right to come on your property. Those, at one point in time, got up to close to $6,000 an acre, just for the right. There was nothing to do about drilling yet or anything. $6,000 just for the right. Then on top of that, there was a thing called a royalty, which means that whatever they suck out of your property, or actually out of the whole unit, or maybe more than one property, you get paid a portion of that. So you get your bonus payment just for the right to use it, to go on your land. And then there was a royalty payment for the extraction of the minerals. It used to always be an eighth. I mean, it was always 12.5% was always what the standard going rate was. Negotiable. Every term is negotiable. And it was in the pre-printed form, so people were just signing it. For a large gas play, if you got an increase from 12.5% to 15%, or to 18%, or in some instances 20%, that could dwarf the bonus payment that you receive based on the amount that's extracted. Negotiate so that you get the best terms. Again, no standard lease. Everything's negotiable regardless of whether it's a printed form or not. Make sure you get advice. Make sure you get everything in writing. Another very crucial fact is get a copy of what you sign. Get a copy of it. Don't let the person who comes and gets you to sign it say, well, we'll mail you a copy later. Get a copy of what you signed. There have been instances where, thankfully, people have kept copies, and the copy that ends up getting recorded in the county clerk's office has different terms because somebody else wrote them in. And let's assume you didn't keep a copy, and your signature's on that form. They'll say, well, that's what you signed. And you need to be able to have a copy of what you signed to match up against it to make sure that that is accurate. So demand a copy of what you sign right then and there. Then I would say that you put in writing and demand a copy of the signed lease after it's been signed by the gas company, because they don't sign it initially, and negotiate a term that says it's not effective until you receive a signed copy from the gas company.
Mike, one other thing that most of us didn't realize is that we actually have, if we have a mortgage or a home equity loan, signing a gas lease without the permission of the bank, the permission of those who lent you money, is violating your mortgage. Because the mortgage is basically, as you know, their interest is your property, and you've now signed away some of the interest in your property. So we're finding that they're not calling the mortgages, but they're not giving mortgages, many banks, on leased property unless you can get a release of 5 acres around your house.
Right. People need to understand whether it's a gas lease or a mortgage or a judgment against them. Anything that is a lien against the real property takes precedence over any subsequent thing that occurs on the property. So if it's in New York State, we're a race notice state, which means the first one to race to the county clerk's office and file the document wins. And so if you have 2 mortgages outstanding and one gets it filed before the other one gets it filed, it's the first one takes precedence. So and then any subsequent filing takes their interest in the property subject to any prior liens and encumbrances. So first of all, a mortgage, 2 instances. You have a mortgage on your property and then you sign a gas lease. Well, your mortgage takes precedence over the gas lease, except to the extent that that the bank could, depending on what the terms of the mortgage are, could say that by executing that lease it impaired our security interest in the real property and could impact our ability to do that. As was mentioned, the banks, is my understanding, have not been calling those mortgages that people subsequently can get liens on. But you got a couple of issues. One is that a bank may, if you already have a lease on your property and then want to get a mortgage, a bank may have reservations about doing it, maybe or maybe not, depends on the bank. Second of all, if you went and get a lease subsequent, you may want to check with your bank first before signing the lease. That's why you go to your attorney and you talk to them about these sorts of things to see what impact it may have. Now, the bank may say, no, we don't want you to have one. Or the bank may say, yeah, it's okay, but you got to make sure that 5 acres around the property where the well is and the septic and the house and all that are are not subject to the lease, then maybe that's okay. It all depends. So these are all factors that people need to take into account in making these particular decisions. It's a weighty decision that people need to make. Don't be blinded by dollar signs when making these particular decisions. And do your due diligence and investigate. And ultimately, if you were to enter into this a transaction like this, that you'll be comfortable saying that you got a fair deal. And that's the most that I can hope for you, is that if you choose if you choose not to do it, then great. If you choose to do it, it's important that it be fair to you. Now, maybe somebody down the line will get a quote-unquote better deal. But the most important thing is that when you sign on the line, that you understand every single term and that you believe that it's fair for you. And if you do that, you've done your due diligence in being a good consumer. And hopefully you will be comfortable with your ultimate decision, and then you don't have regrets later on for those that somebody might have if they signed one without knowing any of this stuff that was going on. The area is in flux now. We've got cases that have to be decided. We've got an environmental review that has to be completed, and nobody knows when that ultimately will take place. And then the market has to then come in and kind of dictate whether things are going to happen. So there's a lot of things that are out there moving around. But I hope that with our session today, you will have kind of gotten the lay of the land, and that you will be a good consumer and that ultimately make a good decision for yourself.
There's some other things, though, that people can't know yet, which is that the major national companies are refusing to give homeowners insurance to people with a gas lease. And so that's not something that's written into the contract. But if you can't get homeowners insurance, you can't get a mortgage, you're not going to be able to sell your property. This is kind of late-breaking news, so that's something it's hard for a consumer to know.
Well, consumers are entering into a business transaction. And before they enter into that transaction, they have to know. They have to investigate these things. They have to talk to their homeowner's insurance. They have to talk to their mortgagee. They have to talk to their attorney. They have to understand all of these issues that may crop up later on. As a word of comfort, gas leasing has been going on for years. There's been much more developed areas than New York. New York is almost kind of a baby in this whole thing. I mean, Texas, Oklahoma, they've had these situations for a long, long period of time. And they had an active drilling, oil and gas. And so these issues are going to come up nationally. And that, for example, insurers. I mean, insurers have had these issues cropping up. People have to investigate, what works out best for them as far as getting coverage. People are insured down in Texas for their homes, and they have gas leasing. So as things are in flux and wind themselves out, then we'll have a lot more answers for those sorts of issues.
Mike, thank you for helping us better understand our rights and responsibilities as landowners regarding gas and oil leases. As with all of our consumer issues, we really need to become informed and know what questions to ask before we make these kinds of important decisions. And I hope that this has increased your confidence and understanding of the issues that we face regarding these leases. We also have more information on our website, which is ccetompkins.org. Thanks to all of you for joining us today. We have additional information on this and other consumer issues on our consumer helpline. And if you'd like that, please call us at 272-2292. Our staff is available to help consumers explore their options, and we provide unbiased, research-based information on this and many other issues. If you'd like to join us live, we are here at the CCE office at 615 Willow Avenue in Ithaca on the second Thursday of each month at 11 a.m. Our programs are free and open to the public. Our topic next month is an overview of the ins and outs of insurances, and we hope to see you then. Thank you.
Hi, I'm Andrea Hatfield. If you're a real estate professional, a home buyer, or seller, radon in indoor air is something you should know about. It is a serious health risk, but there's simple and inexpensive ways to test for it and to fix it if necessary. Like any health risk today, it's something more and more people know about, either through a home sale or through the media.
The National Radon Test is about to begin.
Have you heard of radon?
Radon?
Radon.
Is it something that comes up out the ground or something?
Is that a gas?
Something dangerous that you're supposed to check on to make sure it's not in your home.
It's a naturally occurring radioactive gas that percolates out of the soil and comes into houses.
Radon is the second leading cause of lung cancer.
You can't see it or smell it either, right?
That's right.
Yeah.
And so there was 2,000 deaths attributed to this in California.
The Office of the Surgeon General recommends all homes be tested for radon.
False. False.
It's true.
True.
New homes can be built to protect your family from radon.
If I don't take care of it, nobody else will.
1-800-SOS-RADON.
You see, she's the brighter sister.
Yeah, I told you. Sometimes a little comic relief is the best way to deliver a serious message. But once you're aware of an issue, the next thing to do is learn more about it. Radon is a naturally occurring, invisible, and odorless radioactive gas that comes from uranium in the ground. Outdoors, it's dispersed into the atmosphere. Inside, it can enter through cracks in foundation walls and floors or other openings to the ground like a sump and become trapped in your home. This is when it becomes a problem. Research has shown radon to be the nation's second leading cause of lung cancer, right after cigarette smoking. The National Academy of Sciences studied data from minors exposed to radon, as well as from people living in homes with elevated levels of radon.
We have this very extensive data from the minors on one hand and from the general population on the other. We can measure the risks in the two groups, and they give us just about the same signal. The National Academy of Sciences committee estimated that radon was the second leading cause of lung cancer in the United States, causing perhaps 15,000 to 20,000 lung cancer deaths a year. It's a carcinogen that we can do something about by making measurements of radon levels in homes and taking steps to reduce the levels if they are too high.
You should test no matter where you live. Radon has been found all over the United States. About 1 in 15 homes will have an elevated level. Testing is the only way to find out. There are some parts of the U.S. that have potentially higher levels of indoor radon, such as Zone 1, shown here in red. But there have also been homes with elevated radon levels found all over the country, and levels can vary even between adjoining houses due to the type of construction of a home and its local geology. It's important to remember that any kind of house with a high level of radon can be fixed. It doesn't matter whether it's old or new, large or small, single family or townhouse. When a home goes up for sale, it's important to know its radon level.
Sellers and real estate professionals representing sellers, marketing the home for sellers, must always disclose what they actually know about radon in a home. If, for example, it's been tested and identified to have high levels of radon, that must be disclosed to prospective buyers. If high levels of radon have been found and it's been fixed, that should also be disclosed to buyers.
Okay, let me let you follow me out to the deck area.
Nancy Davis is a realtor who's made radon testing and mitigation a successful part of her business.
Fenced in.
I think it's just something that we have to learn about and to deal with, and I think that it was something that purchasers and our buyers and sellers were very concerned about because they just didn't know enough about it.
Well, it sounds like this is something that's a frequent part of your transactions.
It is, absolutely, and I think that it's important that we do have a guide, and all the telephone numbers, any questions and answers are listed in the book. If they have any pertinent question, they can call their local office.
So every state has a radon office?
Absolutely, in the District of Columbia as well.
The Home Buyers and Sellers Guide is an excellent source of information on indoor radon, along with the Consumer's Guide to Radon Reduction. They'll introduce you to the most important facts on radon and how to fix it. One of the first concepts to learn is how radon is measured. Here's the magic word, picocuries. Radon is measured in picocuries per liter of air and sometimes in water. Your test will tell you the radon level in the air of your home expressed in picocuries per liter. Outdoor air has an average of 0.4 picocuries per liter. The average level indoors in U.S. homes is 1.3 picocuries per liter. The EPA recommends fixing your home if you find a level of 4 picocuries per liter or higher. You may also want to consider fixing your home if the level is between 2 and 4. If you smoke and have an elevated radon level in your home, you should be especially concerned. Your risk of developing lung cancer can be more than 10 times higher than someone who's never smoked. Okay, now you know the numbers. The next step, how to do the test, or how to get the test done if you're the buyer. You can do it yourself with a test kit like this one for a minimum of 48 hours. Or you can hire a professional. They'll either use a passive device like this one or a continuous monitor. These devices are electric and collect radon level data in 1-hour increments. If you're using a passive testing device, you'll need 2 for best results. There's several different types of tests available today. While a professional test costs in the range of $75 to $200, do-it-yourself kits cost from $10 to $30. You can order kits like these from a phone hotline or pick them up at a retail store. Some tests are made to stay in your home for more than 90 days. While they can give you a reading that's more likely to tell you your home's year-round average radon level, many people selling or buying a home don't have that much time. You'll need to read the instructions carefully. They'll tell you where to put the test device, where not to put it, such as a laundry room or stairway, when to do the test, and how long to leave it in place. Once you've left the device in place for the specified period of time, you send it to a lab to be analyzed. You'll get the results back in anywhere from a few days to up to 2 weeks. But let's say the seller hasn't tested their home and the buyer makes a test part of the contract offer. Typically then, the test would be done as part of the home inspection, and many home inspectors are also qualified testers. Check with your state radon office to get a list of qualified inspectors in your area.
Today we're going to be doing a passive radon test.
Bob Graham has been doing radon testing as part of his business for over 10 years.
It's become quite typical to do a radon test as part of the sales process today, and generally the buyer negotiates that when he signs the real estate sales contract. The test that I do takes 48 hours in place. It's a short-term passive test, and it costs $140.
Home inspectors can also check existing radon mitigation systems to make sure they're working. Graham says he often runs across misconceptions about radon.
Radon is an invisible gas, and there's no way to tell whether it has radon without actually testing the house. It has nothing to do with being an old house, a new house, having a basement, not having a basement. You just simply have to test.
So whether you're the seller who's done the test yourself or the buyer who's hired a professional, what you end up with is the same: a test report showing the level of radon in your home. Now remember, the EPA strongly recommends fixing if the level is 4 picocuries per liter or higher. So let's say you found an elevated radon level. Now what?
Well, basically, we get our estimates. We get the radon experts to come in, and they will give us a range of price, and they'll tell us where they think the equipment should be located and installed.
Well, let's talk numbers, Nancy. Could you give us a range for the cost of repairs?
Anywhere from about $650 to $2,000, and that's pretty much across the country and across the board.
When you think about the cost of the home itself and the cost of any major home repair these days, it sounds reasonable.
The cost is not that expensive. We could be dealing with maybe replacing some windows. It's much less than replacing or repairs on a roof. And it's also important when the sellers are relocating to their new home, they're going to want a test done on their home. And the buyers are going to want to feel safe and comfortable in the home that they've purchased.
Let's say you are fixing an elevated radon level. You can call your state radon office for a list of qualified radon contractors. Then you'll want to check references and get more than one estimate. As we mentioned earlier, many builders are already including radon-resistant features in new homes. More than 40% in the red zone 1 regions and about 20% of all new single-family homes being built nationwide. The features include making the foundation radon resistant. Builders are also installing passive vent piping at the time of construction. Then when the house is finished, you do a radon test to see if you need to add a fan to the system to actively vent radon from the ground. It's cheaper to upgrade the system if you have it roughed in at the time of construction. Paul Jenneman is a contractor who installs radon mitigation systems.
Any house that's in direct contact with the earth can have radon. Old houses, new houses.
Jenneman says even if a house already has a radon system installed, you should still do a test when it's put up for sale.
If you're moving into a house that's got a passive radon system, you should still test for radon. Even if it's got an active system, you should still test for radon. What we're doing here is creating a vacuum underneath of the house, and the radon gas or any other gas in the ground will be attracted to that low pressure field. We're going to suck it out of the ground before it gets into the house and blow it out to the atmosphere where it would normally go if you didn't have a house here.
After the system's installed, test again.
You should always test a house after a radon mitigation system has been put in to assess the operation of the system. Make sure that the radon is an acceptable level.
While more and more new homes are being built with radon-resistant features, what's perhaps more important are the millions of existing homes already out there. Environmental attorney Paul Locke has advised thousands of real estate professionals on their responsibility in disclosing radon information. His advice? Know the basics, know the experts, and disclose early and often.
If you're a broker or agent and you're beginning to list a piece of property, think about radon disclosure at that point. You want to work with your seller to get them to understand that buyers are going to ask questions about radon and that sellers have to answer those questions.
Locke says if you need specific legal advice, consult an attorney. What we've covered in this video is a general introduction to radon. The Home Buyers and Sellers Guide to Radon has all the information we've covered, including the phone numbers for all state radon offices. So call 1-800-SOS-RADON or visit the EPA's Indoor Air Quality website. Learn all you can about radon. You'll breathe a lot easier.